My Lords, good morning. I appear for the appellants in this matter alongside Mac Imrie KC, Mark Tushingham and Ryan Hallett. And I'll refer to the appellants, if I may, as either Ting, Chuan or TC. And my learned friend Tom Lowe KC appears for the respondents alongside Hilary Stonefrost, Gemma Lardner and Corey Byrne. And I'll refer to the respondents as FM or Family Mart. My Lords, the plan of attack is as follows. I'm going to divide my submissions into 6 different parts. I'm going to start, if I may, by looking at the content of the petition and the nature of the proceedings. I'm then going to turn to Section 4 of the Foreign Arbitral Awards Enforcement Act. It's rather a mouthful. I'll try and call it the 1975 Act, which is the basis for TT's application for a stay, to identify what you need to show to get a mandatory stay. In effect, I'm going to look at the ingredients. That's part 2. Part 3, I'm then going to turn to consider whether Ting Chuan is entitled to a stay under Section 4, leaving aside questions of arbitrability. So I'm attempting there to sweep up other points, such as the matters point. So that's part 3. Part 4, I will then turn to consider the meaty issue of arbitrability, which will be the lengthiest section of my submissions. 5th, I'll then turn to deal briefly with Section 95(2) of the Companies Act. I don't think much is going to turn on that in this appeal. It appeared that it might at one stage, but I think it's rather taken a back seat now. And then finally, I'm going to deal with the issue of discretion and whether or not you need to grant a discretionary stay. And in that part of my submissions, I'll deal with FM's arguments that the company is not bound by the arbitration clause and what is the consequence, if any, of that. So that's the plan of attack. And without further ado, my Lords, I'll get straight on with, yes.
Just before you do, Mr. Kimmins, can I just check if you've got your microphone switched on? I think you have to press the, where it says push. You have to push it.
It is on. Are your Lordships having difficulty hearing?
No, I'm having no difficulty hearing you. But I suspect if it's a system like the one we have in London, the sound is only picked up for the live stream if the microphones are switched on.
I'm afraid I'm looking down and I can see no lights or switches of any kind. And I don't know whether that's a good thing or a bad thing.
Well, why don't you just carry on in the meantime? And if
we tried to transfer it to this one specifically.
It might work better if you put a fat textbook under the
Unfortunately, it's screwed down. Otherwise, French would have fitted very nicely underneath.
I suspect if it's plugged in, you might get a green light.
I've got a green light over here.
Right.
But the question is, because they very kindly tried to arrange it to be moved from that one to that one, and the question is, has that worked? I don't know.
Yes. Well, shall we carry on? And if there is any problem with audio, perhaps those who are monitoring the live stream can inform us.
I'm very grateful. My Lord, so the nature of the proceedings and the content of the petition. Part 1. At heart, we say this is a dispute between 2 solvent and highly sophisticated shareholders in a private company. And the preferred relief sought by the petitioner is a buyout order to the effect that TC is ordered to sell its shares to FM, and in the alternative, an order that the company be wound up on just and equitable grounds. There are no third parties involved. FM and TC are the only 2 shareholders, and there are no creditors whose rights will be affected. Now, the petition itself comprises essentially the following allegations, and we'll look at it in a minute. At the instigation of TC, the majority directors appointed by TC have engaged in misconduct and breaches of duty. TC were also in breach of an understanding reached between FM and TC, And this has resulted in FM losing trust and confidence in TC, and FM's relationship with TC irretrievably breaking down. And your lordships will have noted me emphasizing the words TC, and that's in contradistinction to the company, who, as your lordships will have noticed, has not appeared at all in my summary of the allegations in the petition. If I could ask your lordships briefly to look at the petition. It's on page 7 in your electronic bundle. That is the cover sheet to the winding up petition. And I'd like to start, if I can, on page 13 and look at paragraph 29 on page 13, where you'll see reference to the understanding. Just before we look at that, your lordships have this, I'm sure, already, but essentially, this is a convenience store joint venture in China, and FM provide the know-how, FM Group provide the know-how, and the Ting Sin Group provide the infrastructure. But here is the plea of the understanding, and you'll see in paragraph 29, in addition to written agreements, by 2003, there was an agreed understanding, the understanding between FM parties and Ting Sin. Ting Sin was holdco for Ting Chuan, but you'll see in a minute the understanding extends to Ting Chuan. That the party's objective was to maximize the expansion of the FM business and to cooperate in doing so. In particular, the group would use its resources in the PIC to procure from third parties, provide necessary infrastructure, et cetera, et cetera. And then importantly, any such contracting or infrastructure services would be transparent and disclosed by Ting Sin to the FM parties, and then only on the footing that the terms were fair and equitable. So that is your understanding. And then briefly over the page on page 14, at little c at the top, you'll see the understanding has not been superseded by any subsequent written agreements and applied to Ting Chuan once Ting Sin transferred its shares to Ting Chuan. So you'll see the key point I'm trying to emphasize, my lords, is that Ting Chuan is alleged to be party to this understanding. And as you'll see, the allegation is that Ting Chuan was in breach of that understanding. And as you'll also see, Ting Chuan says there was no understanding, and even if there was, we weren't in breach of it. And that's important, because at places in my learned friend's submissions, he appears to hint that it's us who need to rely on an understanding, and that's not right. The allegation of the understanding is made against my clients and forms the basis of the breach of understanding allegation against it. And you'll see in the defense, insofar as it's necessary, my clients say, no, there was none. And if there was, it wasn't breached, because they knew everything that they say we should have disclosed. In any event, that's the understanding. If one then goes over to page 16 of your electronic bundle, you'll see a heading above paragraph 41, disclosed related party dealings. So that's pre-2012. They say there were various dealings, but we don't have such a problem with those. They were disclosed, in effect, the fact that they were related parties. One then goes over to page 12, and you have non-disclosure of related party transactions after 2012. That's on page 12 at paragraph 47 and following. Electronic bundle, page 18. When I said page 12, I was referring to internal numbering. I should have said 18 for the electronic bundle. That's your heading. And then over the page, electronic bundle, page 19, you'll see allegations of breach of duties to the company in paragraph 54 by ongoing trading with disclosed related parties. The majority directors have not made full and frank disclosure. And then 55 underneath, TC have caused, permitted, and procured the majority directors to act in breach. And then you have in paragraph 56 underneath, breakdown of the relationship. The petitioner has incrementally lost trust and confidence in TC. And that's the point I emphasized at the beginning. The very premise of this winding up position is the conduct of TC and the loss of confidence in TC. It's nothing to do with the company. If one then goes on, please, to electronic bundle, page 23, just so that it's a little easier to navigate, you'll see above paragraph 71 another reference to undisclosed and unapproved related party transactions. That's above 71. And one needn't engage in the detail, but over the page, please, to page 25 of the electronic bundle, you'll see similar allegations of breach of duties by the majority directors. And again, Ting Chuan in paragraph 80, and Ting, of course, permitted and procured the majority directors to act in breach of duties. And then you have a similar pair of allegations in 81 and 82 at the bottom of page 25 of the electronic bundle. And then if I can drag you on, please, to page 32. And there you'll see basis for winding up. Petitioner's loss of trust and confidence in the conduct and management of the company's affairs is justified by, and then various points are set out. Paragraph 109 over the page on electronic bundle, page 33. Ting Chuan and Ting Sing acted contrary to the understanding. There's the allegation against my clients that they're in breach of the understanding. And I'll come back to this later, but of course an understanding. My learned friend may well say, well, that's not a contractual obligation, but that doesn't matter at all. As your lordships are all aware from the Westbourne Galleries type cases, this gives rise to equitable rights and equitable constraints. And you'll see there, they acted contrary to the understanding, and the relationship between the petitioner and TC has irretrievably broken down. And then underneath in 110, you'll see, again, references to irretrievable breakdown and breach of the understanding. And the plea for relief is, first of all, you've got mention of wind-up, and you also have mention of the sale of shares. And as we bang on about at great length in our written document, the preferred relief, of course, of my learned friend's clients is a buyout, because this company is one which is extremely healthy. So there's the petition, and I'm going through it in a little detail in anticipation of points made against me in relation to the role of the company in this particular episode. And I'll come back to that later. But having seen the petition, one could be forgiven for seeing this case as being on all fours with a case I'm going to show you in a minute called Freerider, which is a Cayman case, whereby, and I quote, the wrongs claimed and the nature of the allegations are of wrongs by those in control of the company against a shareholder, rather than by the company itself in any real sense. And one can see that strikes a chord in relation to these facts. The company has no separate and discrete interest of its own in these proceedings. One sees this also from the directions which were given by Mr. Justice Kawley in this case. Could I take you briefly to the winding up rules, which are at 2200 of your bundle? And you'll see there under summons for directions, and this is in relation to a petition of this kind. You'll see upon hearing a summons, the court shall give such directions as it thinks appropriate in respect to the following matters. Whether or not the company is properly able to participate in the proceedings or should merely be treated as the subject matter of the proceedings, and whether the proceeding should be treated as proceeding against the company or an inter partes proceeding between one or more members of the company. Oh, I do apologize. Apologies, 2200. And my lord, we're in paragraph 12, and we were looking at 1A, little a and little b. And I was on little b, whether the proceeding should be treated as a proceeding against the company or as an inter partes proceeding between one or more members of the company as petitioners and other members of the company as respondents. It also deals with points such as service of the petition on third parties and whether the petition should be advertised. So those are the points that the court will need to address in a summons for directions. And you can see the result of debate in relation to these matters at 655, which is the order of Mr. Justice Kawley, dealing with the points that I've just shown you in the winding up rules. And you'll see it is ordered that China CBS, that's the company, may participate in defending the petition herein if so advised. And if one goes over the page, this is the important bit, to the petition be treated as an inter partes proceeding between the petitioner and TC, the advertisement of the petition be dispensed with, and you'll see that there is no suggestion that anything needs to be served on anybody else. I should also draw your attention in passing to the fact that an order known as an anticipatory validation order was also granted in this case, That is at 7355. And the idea behind one of those, as I'm sure your lordships are aware, is to make sure that ordinary transactions between the date of the petition and the date of any winding up order may not be challenged, save in limited circumstances. So all signals, we say, point to the fact that you have here a classic inter-shareholder dispute. And as the consent order said, it is treated as an inter partes dispute between FM and TC. The petition doesn't need to be advertised because this isn't a winding up where there are issues with creditors. No one else needs to be served, and the company, of course, has not, in fact, ever become involved. It has not served a defence. It has not become involved in any way. TC filed a defence, and FM filed a reply to that defence. And none of this is particularly surprising in circumstances where no one wants the company wound up. The primary relief which is sought is a buyout. Just to tease my learned friend, and it's a point we made in our written submissions, it is a little ironic that the court refused to stay the petition on the grounds that a tribunal would be unable to make an order which nobody wanted. But there we go. I'll come back to that.
Well, it's not the primary relief they wanted, but it is the secondary relief.
But the preferred relief.
Yes.
So perhaps preferred is a better word, my lord. I think the lordship's right.
And one other point, if I may ask, were these directions made by consent?
They were, my lord.
Those made by the judge that you took to a moment ago?
My lord,
made
yes,
by consent.
it's a consent order.
Thank you.
I wonder whether my learned friend might try and row back a little from the suggestion that what this is all about is a buyout, for reasons which will have been obvious once he'd seen our submissions. But we're a little sceptical about that. And my learned friend says, well, actually, buyouts are quite difficult in circumstances where one has very high-value companies and complex arrangements. And we say, no, not so at all. In our experience, at least, one gets these types of buyouts very regularly, both in court and particularly in arbitration. I have personal experience of many of them. You have, as your lordships will be aware, puts, calls, drags, tags, all those preemption rights in shareholder agreements. And there's constant litigation and arbitration about those, involving very large sums of money. For those who read the fascinating Global Arbitration Review, which I do regularly, you will have noticed last week that there was a review of a award by a JAMS arbitrator who valued a stake at 3.7 billion for the purposes of the exercise of a call option in the Fox litigation. And to give you other examples, in the Deripaska case, Filatona, that was another arbitrator ordering a nearly 100 million buyout in relation to companies. This is bog standard stuff. And I wouldn't want it to be thought that difficult, high-value arrangements are somehow inconsistent with the ability to buy out. If we could have a quick look at the shareholder agreement in passing.
Just before you do, have I correctly understood that the company is in reality just a holding company?
My lord, yes.
Paragraph 8 pleads that the company engages in the business of establishing, operating, and managing convenience stores through or portfolio subsidiaries. In reality, the wholly owned subsidiaries operate all day-to-day business.
Yes, my lord, that may well be right.
Yeah.
May well be right. My lords, page 39, the shareholder agreement, that's the cover sheet. If one looks at page 40 over the page, you'll see all the usual candidates in the table of contents. If I can take you very quickly to page 45, and you'll see section 3.2 there. These are all fairly standard. The second sentence of 3.2, the company shall carry out and conduct its business in a manner consistent with the best interests of the company in accordance with sound, proper business and financial practice. You then have page 50 at 9.1, further obligations of the parties. Each shareholder shall and shall procure its affiliates and directors nominated by it. Take all reasonable steps to ensure that the provisions of this agreement are complied with, and shall do all such other acts and things as may be necessary or required to implement the provisions of this agreement. One then goes to page 58, And your lordships there will see a termination clause. And that's section 19. I'm pausing, my lords, just.
We're just testing the microphones.
My lord, yes.
I can hear mine's working.
Yes, mine's working.
My lords, we were on page 58 looking at the termination provision, and there is one of the usual provisions which says if somebody is in material breach and that is not cured within the cure period, then you may terminate, and when you terminate, you have a buyout option in the agreement itself. You'll see in little 1 and little 2 on page 59 the buyout provisions which deal with that particular eventuality. Finally, on the shareholder agreement, page 60, my lords, over the page, you'll see there an entire agreement and a governing law and jurisdiction clause, and you'll see the arbitration clause in little b on page 60. And you'll see it's in the widest possible terms, and I don't think there is a point on scope. It's accepted that all of matters in the petition fall within the scope of the clause. What's interesting, though, in passing, is you can see that people choose arbitration for a variety of different reasons, and a lot of them appear in this particular clause. You have an arbitration which shall be confidential, shall be conducted in the Chinese language, shall take place in Beijing, the award shall be final and binding. These are all the types of points that are important to parties, and that is why they choose this type of provision, particularly where they are two private, sophisticated shareholders wishing to agree on the operation of a JV. So that is the shareholder agreement, and you might be forgiven for having some sympathy with Mr. Justice Kawali, who at first instance made a couple of remarks to the following effect. If one looks at 134, please, that's electronic bundle 134, and looks at paragraph 17, the most obvious reason for the somewhat obtuse way in which the petition was crafted was the tactical goal of sidestepping the argument which TC did in fact raise. The complaints properly arise in relation to the SHA and are caught by its very broad arbitration clause. And he made a similar remark at page 153, at paragraph 74, where he says, in the present case, the petition includes matters which, shorn of their thinly veiled drafting disguise, clearly constitute claims falling within the scope agreement. They can properly be hived off for determination by the arbitration tribunal, and the present proceedings can be stayed. Should the petitioner succeed and need to seek relief which only this court can grant, it can apply to lift the stay and rely on the findings reflected in the award. My judgment, the obiter dicta of Patton L.J. in Fulham and Jones J. in Cyberwater ad idem in supporting this resolution of the arbitration stay. We say quite so. My lords, can I take you very quickly to Free Rider before I leave this particular topic? The case is at 2959. 2959. And this is a Cayman case at 2959. You'll see in the head sheet, just below the italics, the petitioner sought the winding up of a Cayman company on J&E grounds, and there was a petition for directions pursuant to the rules which we looked at earlier. And so what's useful about this case is it discusses the nature of an inter-shareholder dispute and to what extent the company is involved in a dispute of this kind. And if one goes over the page to 2960, you'll see at the top, it was further submitted the company had an interest in the petition, since if it was successful, it would be wound up and therefore should be allowed to participate in the proceedings. Held, directing the company should be treated as the subject matter of the petition, which would be heard inter partes between the shareholders. And you'll see little 1 underneath. Rather than me read it out to you, I wonder if I can invite you just to read little paragraph 1 to yourselves. I'd be very grateful. course, the point made is that it's not a claim against the company. The company is at best a nominal defendant. Just looking at a few other provisions of this case, if one goes to 2965, and it's interesting to see the type of allegations which were made in this case. Right at the bottom of 2965, you'll see counsel for Mr. Heinen submitted there are 4 main grounds for Mr. Heinen's petition, namely that, over the page at 2966, there's been a significant mismanagement and numerous breaches of fiduciary duty by Mr. Leconte as director of the company, so very much on all fours with what we're seeing in this case. Mr. Leconte has excluded Mr. Heinen from participation in the management of the company. There is deadlock at both management and shareholder level, et cetera, et cetera. So interesting to see the same sort of allegations about directors. If one then goes to 2971, you can see that the court in this case relied heavily on a decision of Mr. Justice Harman in re Hydrasan. At the very beginning of paragraph 25, you'll see the next case of this type was the decision of Harman J. in re Hydrasan. This was an application context of a section 459. And then they then cite an extract from the decision of Mr. Justice Harman below in paragraph 26, where he say, the argument here by Mr. Mobley-Smith is that the first petition contained not only a petition under section 459 for what is commonly called a buyout of the petitioner by the respondents, alternatively by the petitioner of the respondents, but also a claim, as was habitually put in the old days, for a just and equitable winding up. So the point there is Mr. Mobley-Smith is saying this is different here because we've got a winding up. And the answer is, in my view, that's not a complete answer, or any answer to this claim. The claim on the petition in the chewing gum case was purely, simply, and only for a just and equitable winding up. The claim on a contributory's petition for a J&E winding up is not in truth hostile litigation by a shareholder against the company. It is in truth a claim by a shareholder based on the wrongful acts by other shareholders or directors which have amounted to some equitable wrongdoing, even within the articles, as is exemplified in the case commonly referred to as Westbourne Galleries, which went to the Lords and reinstated the width of those petitions. It's quite clear in my judgment that the nature of the petition based by a creditor against the company, which seeks the winding up of a company, is wholly different from the nature of the relief where there is a J&E petition by a shareholder against the company, which may lead to an order for the winding up of the company. It's quite true that if a winding up order is made on a contributory's petition, the company will suffer what I usually refer to as death. That is, it's coming to an end and eventual dissolution. The wrongs claimed and the nature of the allegation are wrongs by those in control of the company as against a shareholder, rather than by the company itself in any real sense. And my lords, rather than take you through endless passages in this case, there's a lot to the same effect. If I can just show you one more extract at 2974, another citation from Mr. Justice Harman. Just and equitable, this is paragraph 29. Just and equitable winding up is frequently, although following the recent practice direction, not so frequently, is formally joined with 459. In a chewing gum case, winding up on the J&E ground was the only relief sought on the petition, yet in that case the judge held the company was no more than a nominal respondent to that winding up petition. The petition was based on misconduct and breach of fiduciary duty many times by the respondent shareholders and directors. Plam and J, finding the misconduct proved, concluded that it warranted the dissolution of the company and putting an end to the relationship between the members, the company being undoubtedly extremely solvent. So again, we say we are on all fours with this in this case. And then finally, before I leave it,
But I mean, this is fairly well established jurisprudence under Section 994 of the 2006 Companies Act, which is derived from prior jurisprudence under the just and equitable ground, isn't it?
my lord, yes. But insofar as it suggested that that distinguishes it from this case, we would say no. And indeed, the whole point of this case is it was addressing an argument when somebody said, it's all about winding up. And because it's all about winding up, that changes the whole thing. And the court says, no, it doesn't.
Yeah, but I think the jurisprudence under Section 994 came from earlier case law
My lord, yes.
on the just and equitable winding up. So you say there is no distinction to be drawn.
My lord, yes.
Yes.
Page 2982, you'll see the key passage. If I could ask you to read paragraph 45, and then I promise we'll leave this case and move on. But if I could quickly ask you to read 45. and then drawing your attention in particular, my lords, to the last two lines of 45. The company must, of course, remain as nominal respondent, but it has, in my view, no relevant interest of its own in the proceedings. And you'll see over the page at 2983, 5 lines down, while, as I have said, the company requires to remain as a nominal respondent, the only active participation it may possibly require is if it needs to seek a validation order or orders to enable it to meet legitimate payment obligations in the ordinary course of its business. So we say so here too.
Which paragraph's that, sorry?
That is page 2983. It's paragraph 46, which started on the previous page. It's about 6 lines down on page 2983 from the top, while, as I have said. And so we say if one looks for an explanation of paragraph 1 of Mr. Justice Kowali's order, which did refer to the company may do X, Y, Z if it is so advised to do so, that covers that type of scenario. So I've gone through that at some length in anticipation of points made against me in relation to the company. But just to let you know where I stand on that, what we will say is that the petition as a whole should be stayed under Section 4. Alternatively, it should be stayed as against TC under Section 4 and stayed as against the company pursuant to the court's discretion, which it obviously has. But that's a point I'll come back to later on, if I may. But it was with an eye to that point that I've been dragging your lordships through that authority. My lords, that's Section 1 done, I hope. And what I want to move on to now is what needs to be shown to justify a mandatory stay under the 1975 Act. And I probably can't do better than to take your lordships back to paragraph 14 of our case at 2046, where you'll see we say in our written case in paragraph 14, in a nutshell, TC's case on Section 4 is as follows. FMCH is a party to an arbitration agreement with TC. FMCH has commenced legal proceedings against TC. The legal proceedings are in respect of matters to be referred to arbitration pursuant to the agreement. Accordingly, TC is entitled to a mandatory stay unless under Section 4, unless the board is satisfied that the matters raised in the petition are non-arbitrable, such that the arbitration agreement would be inoperative. Those are essentially the hoops through which I need to go to get my mandatory stay up and running. Now, before I start dissecting some of those requirements, and as I say, in this section, I'm going to leave to one side arbitrability. I'll come back to that. It's just worth reminding yourself, what approach should one take to the construction of a Cayman statute of this kind? The answer is as follows. One must construe it on, and I quote, broad principles of general acceptation. It's rather a difficult word. The reason is that the origin of Section 4 is, of course, the New York Convention. Section 4 was intended to give effect to Article 2 of that convention. You needn't turn it up, but one has the helpful dicta of the Privy Council and Lord Kitchen and Lord Lloyd Jones in the Gull-Linhas case. And if I could just draw your attention quickly to 3044 in your bundle. And you will see at paragraph 75, this is a decision of the Privy Council relating to the approach to be taken to the construction of the Cayman Islands statute seeking to implement the New York Convention. So in effect, bang point. And in 74, they say, well, it is, of course, a Cayman statute, fine, but they then say, and this is what's important, it by no means follows, however, that the question is to be answered by applying local standards of what constitutes a fair procedure. As with any statute which incorporates into domestic law the text of an international treaty, the interpretation and application of the language must take account of its origin in an international instrument intended to have international currency. That entails, as Lord Macmillan put it, in the interest of uniformity, the word should not be given a local interpretation controlled by what he called domestic precedents of antecedent date, but rather should be construed on broad principles of general acceptation. He refers to various authorities. This principle is just as relevant in determining the scope of application of rules incorporating an international convention as it is in interpreting their linguistic meaning. So it's very important to remember when one is construing Section 4, where it has come from, and what the other courts around the world and those who might be consulted in order to work out what principles are generally accepted. What do they say? We say that's very important. And if you ask yourself, what are the broad principles of general acceptation, to use that difficult word again, we set them out in paragraph 37 of our written case at 2055, where we refer to the modern approach to this particular issue. And this is important, and I'm going to come back to it. It is very important to look at this case through the right end of the telescope. And you're starting at Section 4, and you're looking at this through the context of the arbitration statute. Party autonomy is a fundamental principle which underpins the pro-arbitration approach. Principle promotes certainty and predictability in international commercial relations. Leading scholars have argued that party autonomy has become, or is in the process of becoming, close to universal and incontestable as a unifying principle. And so it goes on. And if one looks briefly at paragraph 39, just over the page, you will see reference to what an English judge, in the case of Sterling and Rand, has described as a discernible trend towards expanding the types of matter that are arbitrable. And this modern approach started in many ways back in 1985 with the Supreme Court in Mitsubishi Motors. But it is very important to recognize the way in which the courts recently have addressed this type of tension. And time and again, they have said, arbitration is not the poor cousin of litigation. And we'll come back to it, but there's a very useful sentence in the judgment of Mr. Justice Mayles in the Norrie case, where he says, the view that arbitration represents a deprivation of inalienable rights is with respect to a very outmoded view. And you see this time after time, particularly in circumstances where there have been clashes between companies' legislation and arbitration. You'll see, as I'll come on to show you, that party autonomy in arbitration wins. And I'll come on to explain why and show you those cases a little later. But my learned friend may take the point, well, this is all very well, Mr. Kimmins, but Cayman is not a well-established arbitration seat. To which I say, well, that doesn't matter at all. We are looking here at whether Cayman needs to respect arbitration clauses in an arbitration, whether seated in Cayman or not. Section 4 is all about a foreign-seated arbitration clause. And in any event, as your lordships may be aware, my learned friend himself concedes that the legislator, supported by various local commercial interests, is also plainly keen to promote itself as an arbitration-friendly jurisdiction. And so from there, my lords, if I could then just take you to some provisions of the arbitration legislation in Cayman, you will see all of this reflected. And where I'm going with this is as follows, my lord. When one looks at some of the authorities, one sees constant reference to certain provisions which appear statute to statute to statute across the world. And they all say the same thing. And whenever those provisions are looked at, the courts say, yes, it's all about party autonomy, and that must be respected. And we have those very same provisions in the Cayman statute. If one looks briefly at 2164, please. And you'll see there, this is the head sheet of the arbitration law in 2012. If one goes over the page and looks at, first of all, 33B. Sorry. Can we scroll down? No, sorry, back a page. I think your lordships are probably ahead of me. Well, there we go. So little 3 on page 2165. Provisions of this law apply where the seat of the arbitration is in the island. So my learned friend says, well, we can ignore everything that we see in this act because this is a domestic arbitration statute. We say, no, that's not the correct analysis. And in any event, you'll see in little 2, provisions of this law apply to every arbitration under any other enactment, whether enacted before or after the commencement of this law, except insofar as this law is inconsistent. And you then get...
But enactment in that context means a Cayman enactment, doesn't it?
My lord, yes.
Yeah.
And if one then looks at little 3, the provisions of this law are founded on the following principles and shall be construed accordingly. And then this is the language that you see time and again in statutes around the world. The object of arbitration is to obtain the fair resolution of disputes by an impartial arbitral tribunal without undue delay. The parties should be free to agree how their disputes are resolved, subject only to such safeguards as are necessary in the public interest. In matters governed by this law, the court shall not intervene except as provided by this law. And then, my lords, if I could take you briefly to section 26 at 2169. And if one looks at 26.1, any disputes the parties have agreed to submit to arbitration may be determined by arbitration unless the arbitration agreement is contrary to public policy or under other laws of the island, such as a dispute is not capable of determination by arbitration. And then 26.2 is interesting because this is, you don't get this in the English Act, but the English courts got there by applying common law principles. But 26.2 sets it out in no uncertain terms. The fact that any other law confers jurisdiction in respect of any matter on the court, but does not refer to the determination of that matter by arbitration, does not mean that a dispute about that matter is incapable of determination by arbitration. So that is a statutory summary, in effect, of the rule that you found in Fulham, whereby their lordships, Lord Justice Patton and Lord Justice Longmore, said, well, it doesn't matter if it says the court may do X or the court may do Y. It's entirely irrelevant. And instead, you have to look much more broadly at the point. And this is important, and I'll come back to it. But it's interesting to see that that principle is, in fact, the subject of a specific provision in Cayman. We say there is no rationale for adopting a different test between a foreign-seated arbitration agreement and a domestic-seated arbitration agreement. And we say that this generous approach to arbitration is to be seen not only in the Act itself, but also in numerous other documents, such as, I'll show you very briefly, the Law Commission papers. Let's look first at 2223. So 2223 is the 2009 discussion paper review of arbitration laws in the Cayman Islands. And if one looks at...
Just before we go there, going back to 26.1, which seems to me to be of some importance, it provides that a dispute may be determined by arbitration except under 2 grounds. One is that the agreement is contrary to public policy, and the other is that another law of the islands, for example, some statute, says that it's incapable of being determined. So if there's no statute saying it's incapable, the person resisting arbitration has to hang his hat on public policy.
My lord, yes. And we say that the section that you've helpfully identified contains the same provisions as you see in many other jurisdictions.
Yes.
And when one comes to look at the sources of inarbitrability, there are 2. And there's almost, this is, I think, common ground. There are 2 things you can look at. One is a statute, and look to see whether there is a statutory exception. And I'll come back to this because it's important. And the other is public policy. And they're both, we say, very difficult to get within. But those are the 2 sources of non-arbitrability. And as Lord Hodges pointed out, that precisely the same 2 sources are reflected in the Cayman legislation.
Yes. Thank you. Could you give me, I'm sorry I distracted you.
No,
the page number you were turning to.
I was turning to 2223.
Thank you.
And we were looking at the review of the arbitration laws of the Cayman Islands discussion paper and looking at paragraphs 1 to 3. And you'll see the Attorney General referred for the review of the Law Reform Commission, the 1997, that act referred to at the top, the Foreign Arbitration Enforcement Law, is the 1975 act that I referred to earlier. But there was a 1997 revision, but it's the same act. The objects of the review are threefold.
I'm just thinking about the exchange between yourself and Lord Hodge a moment ago. The other law wouldn't, I think, have to expressly refer to arbitration at all, would it? You could have, and I'm thinking, for example, matrimonial proceedings. Only a court can grant a divorce.
Yes, your Lordship's absolutely right.
But on the other hand, maintenance might be capable of being, well, there might be a public policy objection to maintenance being determined by arbitration, but it wouldn't be inherently impossible, whereas divorce would be inherently impossible.
Your Lordship is bang on as always. I'm going to take you to some statutes so that you can see how it operates in practice. Yeah. And the submission I'm going to make is one which reflects a book by a character called Gary Bourne, who's very well known in the arbitration world. And what he says essentially is, unless there is a pretty clear exclusion under the statute, then arguments of arbitrability will fall on fallow ground. And he's right, and I'll show you why later. But your Lordship's right that there are different types of approach. And you never see, I don't think, this issue may not be determined in arbitration, but what you do sometimes see is you may not waive your right to go to court on this point. And we have that in matrimonial legislation and in some consumer legislation. And it is those that Lord Justice Patten refers to in Fulham when he is assessing this very question, because he goes through the two hoops I've just described. Point one, he says, let's have a look at the statute. And he's looking at the unfair prejudice statute, and he says, well, there's nothing in this which says anything to the effect that you can't oust the jurisdiction of the court, and therefore you can. He then moves on to public policy, and you'll see he's going through the two hoops identified by Lord Hodge that we saw in section 26. But the two that he identifies as satisfying the requirements necessary to show a statutory exception are a matrimonial one and a consumer one, and I'll show you that later. But again, going back to the Law Commission review, which was at 2223, it's not coming up on my screen, but I hope it is on yours.
Yeah.
Yes.
And looking at 2225 over the page, you'll see the objectives of the review are threefold: to determine whether a single regime of arbitration should be formulated on the basis of UNCTRA, to ensure that the law on arbitration is responsive to the issues surrounding the resolution of domestic and transnational commercial disputes by enabling the business community and arbitration practitioners to operate in a regime which is consistent with acceptable international arbitration practices and developments. That's important, because it's saying we need to make sure that we are towing the party line here. And that's no surprise, because they are subscribers to the New York Convention, so they've got to toe the party line. To consider whether any steps can be taken to promote the Cayman Islands as a jurisdiction of choice for international arbitration. If one then looks at page 226, and you'll see in paragraph 7 there, the critical aspect of arbitration is based on an agreement between parties to conduct proceedings outside the publicity and formality of the courts of law. Such agreement cannot come into existence unless the parties contractually undertake to pursue its creation. The result is that an emerging arbitration agreement becomes a primary source of the rights, powers and duties of the arbitration tribunal. Among the potential advantages that may emerge from engaging in arbitration proceedings are the flexibility of the arbitration procedure, privacy of arbitration proceedings, opportunity to determine choice of arbitrator, finality of arbitration proceedings, opportunity to identify a neutral forum to conduct the proceedings, efficiency and cost effectiveness. And the reason I'm showing you this...
What they haven't also mentioned is the extraordinary facilities for enforcement around the world under the Convention.
Indeed, indeed. And that's, your Lordship's absolutely right, in that is perhaps one of the most important attributes of arbitrating. But I'm taking your Lordships to this, just having had an eye on the shareholder agreement in this particular, the arbitration clause in this particular shareholder agreement. That's exactly what they're doing. They're saying, I want China, I want Chinese language, I want finality. These are all carefully negotiated points that you see in arbitration clauses day in, day out. And it's important. And we say, this is the essential starting point. This is the end of the telescope that you are looking at this whole matter from, through that arbitration clause, which has been agreed between the parties, and we say that's your essential starting point. If I could just show you very briefly the final Law Commission report at 2242. And if we could go, please, to page 6 at 2247. And you can see the reference to the Law Commission publishing the consultation paper. And then in the third paragraph, the general purpose of the reform is to modernize the arbitration law of the Cayman Islands and to make it more user-friendly. The critical element of the modernization relates to ensuring that the bill provides for party autonomy in the arbitration process while limiting judicial intervention. Now, that was the key background to the act which I showed you previously. And again, what you can see happening here is Cayman saying, we need to keep up. And that is why you then see the provisions which you see in the 2012 Act. And we do say, insofar as my learned friend says, well, listen, you can just strike a line through the 2012 Act because it's about domestic arbitrations. We say that would be an extraordinary way of treating the provisions in that particular Act. And indeed, the general consensus is that you are more generous to foreign arbitration proceedings in terms of arbitrability rather than domestic. And that is all part of the universal global system and being nice to your neighbours. And you see that in the Gary Bourne book.
It might be said that the domestic arbitration rules give you an insight into where the legislature thinks public policy can come into play.
Yes.
And as you say, when it's international arbitration, if anything, there tends to be more restraint in the assertion of public policy.
Precisely, and that's exactly the point made by Gary Bourne in his book. Yes, if you bear with me. Sorry, I've lost temporarily that particular reference, but can I give it to you in a minute once it's dug out? It's in our written case.
Yes, thank you.
6952. I'm very grateful. So, my lords, on to part 3 of my submissions. And here I'm looking at the ingredients of section 4, leaving aside arbitrability for the moment. And we looked at a passage from our written document and traced through the 4 ingredients. And just to take them in turn, there only appears to be a dispute as to one. It is common ground that FM is party to an arbitration agreement with TC, and we understand it to be common ground that FM has commenced proceedings against TC within the meaning of section 4. So the battleground here relates to what is and isn't a matter. Now, in relation to matter, matter sits along scope in the following way. There are 2 questions which you have to ask, and you'll see this in the authorities, which I'm going to show you in a minute. Question 1, the court must first determine what the matter or matters are in the court proceedings, and having done so, the court must then ascertain whether the matters fall within the scope of the arbitration clause on its proper construction. So those are the 2 legs of the test. And the battleground between us relates to the first of those only. It's not in dispute that everything falls within the scope of the arbitration clause as a matter of construction. And that's no surprise given the modern approach that you see in cases such as Fiona Trust. So the battleground is how granular are you in identifying a matter? Now, there are 2 lines of authority on this point. The first, which we say is the correct one, you see in a case called Ruhan, Mr. Justice Popplewell, Tomalugan, which is an excellent judgment I'll be taking you to on a number of occasions, and Mozambique, the recent decision of the Court of Appeal, Lady Justice Carr. That is what we say is the correct analysis of this point. There is a different analysis in a line of authority commencing with a case called Tanning.
Case called?
Tanning.
Canning.
Tanning. And and this is an Australian case.
Tanning, yes.
And what we say has essentially happened is that Australia has adopted a slightly different test, and everyone else has adopted the Mozambique test. Now,
It's the High Court of Australia.
yes. Yes, I'll take you to it. Its origin is a dissenting judgment of two judges in the Australian court in the case of Tanning. And we'll look at it in a minute, and we'll look in particular with what Tomalugan said about Tanning. Because when this point came up in Tomalugan, they had to decide, well, what do we do here? Do we like the Tanning approach? And C.J. Menon said, no, we don't, because we find it incredibly difficult to understand. Now, I should say, before I get into matter, that we say it does not matter on the facts of this case, because the Mozambique test is to get very granular and identify any issue which arises. And it couldn't possibly be said that, for example, what we describe in our document as matters 1 and 2 or 3 and 4, all of them are clearly issues within the Mozambique test for a matter. So that's enough to get us home, unquestionably. But even if we're wrong on that, and Tanning was to apply, then you apply this sentence, which I'll come back to later, is quite difficult to understand. But the Tanning test is this, that you need to show some subject matter, some right or liability in controversy, which, if not coextensive with the subject matter in controversy in the court proceedings, is at least susceptible of settlement as a discrete controversy. Now, that's the Tanning test. And one might be forgiven for having some sympathy with the Singapore Court of Appeal when they looked at this. And they said, well, I just don't know what that means. And they described it as malleable, and they applied first principles. And that was taken up, we say, absolutely rightly by Mr. Justice Popplewell and Lady Justice Carr, who said essentially this. When you're looking at party autonomy and a New York Convention clause, you identify any matter which falls within that clause, and that is taken off to arbitration. It has to be. Now, an inter orem argument is run that that is spectacularly inefficient, and I'll come on to that later. But as a matter of pure logic, we say that that is plainly the right approach, and that the way one mitigates fragmentation in that type of scenario is by the use of case management powers, which I'll come on to. But let's look at the two lines of authority, just so you can see how they play out. But if I may, I'm going to take it relatively quickly because I say it doesn't matter. And just to reiterate that point, applying it must be susceptible as, it must be capable of resolution as a discrete controversy, let's apply the Tanning test to our matters 1 to 4. They are all susceptible of resolution as a discrete controversy in any event. And therefore, you don't really need to decide this point. But nonetheless, it's very interesting, and I'll take you briefly through the two lines of authority.
Yes, it may not, on your approach, matter in this case, but it's a rather important point.
My Lord, yes.
Which this court may have to tackle in order to give the necessary guidance.
My Lord, yes. Yes,
So
that may well be right. Well,
So don't rush it.
I have the point, my Lord. I have the point. Let's start, if we may, with, we say, the impeccable judgment of Lady Justice Carr in Mozambique, which is at 4160. 4160.
Thank you.
And this is the last word on the point. Now,
In the sense of being the most recent word
yes.
on the point.
Well, Your Lordship's absolutely right to take me up on that. So here we have a note. We do have the full report in what is called the FSB, but I don't intend to go to it. given that I suspect you're all operating your electronic bundle in the EB rather than the FSB, and I don't want to have to make you change.
My only slight problem was not really having much of a feel from the extract as to what the underlying dispute was all
Yes,
about.
my lord, I quite understand. I shall tell you.
Thank you.
It is a case in which the Republic of Mozambique makes claims in court proceedings for conspiracy to injure by unlawful means, deceit, bribery, dishonest assistance, and knowing receipt against various companies relating to the supply of equipment to the Republic of Mozambique. So a supply contract and allegations of, in effect, tortious conduct. The defendants say this is all governed by an arbitration clause in the supply contracts, and therefore there must be a stay. The question arises, did any of the matters raised by the claim or the defense fall within the arbitration clause? And you'll see a lot of talk in this case is whether a matter can be something you find in a claim or something you find in a defense, or both. And there was a big debate as to whether anything in a defense actually qualified at all. And they held, yes, it did. And that followed various other prior decisions. But that's not something which concerns us. What we're concerned with is how they then sought to analyze what constitutes a matter for the purposes of that application for a stay. And it was in the process of looking at that point that you see the paragraphs which are at 4160 and following. At 4160, you have section 9 of the English Arbitration Act, which again refers to matters in precisely the same way. I don't think it's suggested that matter in that act is to be construed in any way differently to the word matter in the Cayman Act. So we're looking at the same thing. And then in 4161 over the page, you can see Lady Justice Carr looking at this point. So you'll see a matter is not the same as a cause of action. And my learned friend accepts that. So that much is common ground. It includes any issue capable of constituting a dispute under the relevant arbitration agreement, and a mandatory stay under 9.4 can be applied pro tanto, as reflected in the words so far as they concern that matter. Now, just pausing there, I wouldn't want it to be said, well, hold on, the Cayman Act doesn't have the words as reflected in the words so far as they concern that matter, but that doesn't matter for the following reason. The Cayman Act is based on the 1975 English Arbitration Act. That very clause was the subject of analysis in a case called the Toyuti. You needn't turn it up, but for your reference, it's 4326 and 4332. And in that case, they considered whether the 1975 English Arbitration Act and the provision relating to a stay applied pro tanto. In other words, can you carve up a claim into various different matters so that you only stay those which are caught by the arbitration clause? Answer, yes. So there's no difference in terms of the Cayman statute to the English statute. The starting point is the same, but I wanted to make that plain in case you looked at the statute and thought that that was a relevant point. So there are two stages of inquiry. I'm reading from paragraph 64, although there may be overlapping consideration. First, to identify the matters in respect of which proceedings are brought. Secondly, to assess whether those matters are matters which the parties have agreed to be referred to arbitration. That is to be resolved by reference to the scope of the relevant arbitration agreement properly construed in context. Not every matter that could theoretically be arbitrable is one that the parties are necessarily taken to have agreed as a matter that must be referred to arbitration. And then what she then does is cite Mr. Justice Popplewell in the Ruhan case. And again, I don't want to drag your lordships through this and read it out to you. I do think the most efficient course would be for me to invite you to read paragraphs 43 and following, which you'll see that the citation from Ruhan, which will take you all the way over to the end of the next page, if that's all right. So you'll see so if you could read to the end of that citation from Tomalugan and Sundaresh Menon CJ, if I could ask you to read to the end of that, I'd be very grateful.
What isn't being discussed here, but no doubt you'll have to come on to because it really seems to be the central issue, is the situation where it's arguable that fragmentation of proceedings would undermine the exercise of a statutory jurisdiction.
My Lord, I will come back to that as a specific issue.
Yeah.
But one needs to be very careful when arguing that a procedural irregularity is ever relevant in the context of arbitrability. And I'm going to come back to that. It's a very important point. But just pausing here, we're looking at matter only at this stage. We're not looking at arbitrability. And just to identify a couple of points in this passage before we leave it, at the bottom of page 4161, you will have read a little 4, which reads, further in considering the claim, the court should look at the nature and substance of the claim and issues to which it gives rise, rather than simply to the form in which it is formulated in a pleading. Now, my learned friend says, well, there are some prior authorities which follow tanning, but under English law, but one needs to be very careful because what we say, and I'm giving my learned friend notice of this, is that if you look at those prior authorities, the only point that they are good for is little 4 that I've just shown you, because that point was in tanning as well. And where you see the odd English case which says see tanning, what those English cases are saying see tanning and paragraph little 4, the principle in paragraph little 4. They're not saying let's apply this rather amorphous principle from tanning. And it maybe I need to develop that in reply, but I wanted to give my learned friend a heads up that that was our point. The other point to note at 4162 is that the position of Popplewell J was consistent with Tomalugan, and we'll look at that in a minute, but also you'll see in paragraph 66 there is a footnote little 7 about 5 lines down, and that refers to 2 other English authorities. So we say there is a real body of authority here which has emerged. It starts with Ruhan, goes to Tomalugan, goes to Mozambique, and is being applied in these English cases as well. So,
is the footnote an editor's note?
sorry,
The footnote, is that an editor's note, or is that part of the...
I think it's part of the, I think it's part of the judgment. I think it is. I'll make sure that that's double checked for you, my lord. And then if one goes over the page to 4163, before we leave this particular point, paragraph 70, it is trite law that an arbitration agreement is a contractual agreement to which statute dictates that mandatory effect must be given insofar as it applies. That's the Ruhan case referred to there. The application of Section 9 to give rise to particular difficulties, both as a matter of analysis and procedure, but the sanctity of the parties' agreement takes priority. Thus, whether or not there is futility in practical terms of any stay is immaterial. Equally, the fact that there may be, on the facts of this case, particularly acute, unwelcome case management complications, if all or parts of the claim are stayed, is irrelevant. These are complexities which flow from Section 9 and ones which will often arise in multi-party, multi-issue litigation such as this. Now, that's obviously a very important point, which I'm going to come back to, particularly in the context of arbitrability. But, my lords, that is what I call the Mozambique matter test.
Just before we leave it, why isn't futility relevant to one's construction of the arbitration clause? In other words, if the literal application of a granular matter test would lead to a conclusion that the rigid enforcement of the arbitration clause would be an exercise in futility, you might, as a matter of construing the arbitration clause, might you not, stand back and ask, is that what it really means?
Well, my lord, it conceivably might go to scope, but
Yes.
But
And that's what I'm getting at.
But as a different point, scope is not the question before your lordships. We're all agreed on scope, and therefore what we're looking at is how to deal with a case where it is common ground that everything falls within the scope of an arbitration agreement. And there are really two issues in play. If one takes a step back, you've got the matter point, issue 1, and you've got arbitrability, issue 2. But one needs to be very careful to proceed on the right hypothesis, which is that we are within the scope of the arbitration clauses in any event. And that's your starting point. Now, how is the Mozambique test applied in practice? What I'm going to do next is take you to the Tomalugan case and show you what those matters were and what the court found was the correct approach to identifying matters for the purposes of the applicable section of the legislation. And then what I'm going to do is then look at the other test, the Tanning test, and see how that is applied in practice. And I think you'll see at the end of that analysis that nothing in this case will actually turn on the difference between the two tests. But nonetheless, let's start with Tomalugan. If we can go, please, to page 6620. So 6620, you'll see we are in the midst of Tomalugan. Your Lordships may be familiar with it. It is a unfair prejudice petition where relief sought includes a buyout, orders regulating the conduct of a company, and a wind-up. And there are certain shareholders who are party to an arbitration agreement, and there are certain shareholders who aren't. So all the fragmentation type issues all arose in Tomalugan, and I'll come back to show you how the court dealt with them when addressing the question of arbitrability. But for the moment, it's very important to focus on the issue of matter and how that point was dealt with in isolation. And if one looks at 6620, one can see that there were essentially 4 complaints. And the first is in paragraph 15. Silica investor, that's the petitioner. Complaint of oppression or unfair prejudice is supported by allegations that the judge classified into 4 broad categories. We shall use these same categories in these judgments since they were adopted by the parties on appeal. The first category we shall refer to as the share issuance allegation, and that is in effect a dilution allegation. If you then go on to paragraph 16, the second category of allegations we shall refer to as the management participation allegation. Silica investors claim that there was an understanding or legitimate expectation, so exactly what we have in our case, on its part that it would participate in the management of AMRG. AMRG is the company. And then in 17 underneath, the third category of allegations we shall refer to as the guarantees allegation, and that is in effect an allegation of related party transactions. And then in paragraph 18 underneath, the fourth and final category of allegations we shall refer to as the asset exploitation allegation. And that again is undisclosed related party transactions. So you have a very similar set of allegations. And the question then arose, well, what are the matters for the purposes of applying the relevant statutory provision, just as they do in our case? So if one looks at 6653, and you will see at 108 towards the bottom of 6653, the applicable principles. It will be evident that in considering whether a dispute is governed by an arbitration agreement, the court is concerned with establishing whether the dispute pertains to a matter that is subject to the arbitration agreement. In our judgment, there are 2 stages involved in this process. The court must first determine what the matter or matters are in the court proceedings. It must then ascertain whether the matters fall within the scope of the arbitration clause. It's clear that the court proceedings which are sought to be stayed may be in respect of more than a single matter, and in those situations, the court's obligation is to stay only that part of the court proceedings which concerns the matter or matters that fall within the arbitration clause. This is clear from 6.2 of the IAA, which mandates a stay only insofar as the court proceedings relate to the matter. That's the pro tanto point, and the English provision in the 1975 Act is construed in the same way as I mentioned earlier. And then this is the interesting bit in 109. In the present case, the parties do not agree on the approach at either of the 2 stages of the inquiry that we've set out above. The disagreement at the first stage raises a methodological question, which centers on the degree of specificity, lots of difficult words, with which the court should characterize a matter. Silica Investors argues that a broad approach should be adopted, with the court seeking to identify the essential dispute or main issue between the parties in the court proceedings. On this view, Silica argues the sole matter in the suit is whether the affairs of AMRG have been conducted in an oppressive or unfairly prejudicial manner towards it as a minority shareholder. Lionsgate, on the other hand, adopts a more granular approach. It contends the court is entitled to segment as a separate matter each issue which is material to the relief sought and or is capable of settlement as a discrete controversy. On Lionsgate's view, each of the four categories of allegations made by Silica Investors constitute a separate matter. There is then debate about the Australian tanning approach, and one sees that in 6655. In paragraph 112, they say in Australia, the prevailing test to determine what constitutes a matter is whether there is the assertion of a right or liability which is at least susceptible of settlement as a discrete controversy. And they then refer to the tanning case. And then in 113 underneath, in our judgment, the starting point of the analysis is the language of Section 6, which clearly recognizes the court, when faced with a stay application, is not presented with a binary choice. Combines it to either staying the proceedings entirely and so forcing the parties to arbitrate, or refusing the stay and allowing the court proceedings in their entirety to continue. Section 6.2 contemplates the court is to stay the proceedings so far as they relate to that matter. This seems to us to militate against taking an excessively broad view of what constitutes a matter, treating it as a synonym. In our judgment, when the court considers whether any matter is covered by an arbitration clause, it should undertake a practical and common sense inquiry in relation to any reasonably substantial issue that is not merely periphery or tangentially connected with a dispute in the court proceedings. The court should not characterize the matter in either an overly broad or unduly narrow or pedantic matter. In most cases, the matter would encompass the claims made in the proceedings, but that's not an absolute or inflexible rule. We take this view for three reasons. And then first, the first point you'll see in 114, and here the point they take is, we just don't understand the tanning test. The semantic distinction, they say, between a discrete controversy and a mere issue, the criteria upon which the traditional test is based, is so fine it may be illusory. This distinction has been described as one of fact and degree, to be determined by reference to the whole matter in controversy in the court proceedings, Flint, Inc. But such a test eludes consistent and predictable application. Both labels are so malleable that in the present case, Silica and Lionsgate, applying precisely the same test to precisely the same facts, have arrived at opposite conclusions. Secondly, they say, the courts both in Australia and in other foreign jurisdictions have retreated somewhat from characterizing a matter too broadly. The first instance decision in Tridon is a case in point. They then go through Tridon. I needn't take your lordships through it, but if one goes over the page to 6657, the point they're making is the modern trend is to get granular. The bottom of 6657 at 119, to similar effect is the BVI High Court decision of Zanotti, and then they go through that point. They then, on page 6658, look at the approach of Andrew Smith J. in the Lombard case, where he said in 2012, it seems to me that if the parties have agreed to refer a matter to arbitration, a party who so wishes should be entitled to have the agreement upheld and have the court stay the proceedings for that purpose. This might lead to legal proceedings in which a referred matter is being stayed while that matter or issue is referred to an arbitral tribunal, and then resuming when it's been resolved in accordance with the parties' agreement. This might be inconvenient, result in additional costs and some delay, but that is the price of respecting the parties' agreement and a risk that they are taken to have chosen. And then in 121 underneath, our third and final reason for rejecting the broad approach canvassed by Silica is it's ill-suited to the reality that disputes may be complex and engage disparate factual and legal issues. Characterizing a matter at an unduly high degree of abstraction may carry with it the elegance of simplicity and convenience. Any attempt to boil down a complex dispute to a singular aspect of its essence would be contrived. So for a number of reasons, they say, listen, we don't like tanning because it's very difficult to apply, it's malleable and vague. And then critically, over the page at 6659, in 122, paragraph 122, we therefore consider that a matter for the purposes of Section 6 of the IAA should not be construed in either in an overly broad or an unduly narrow way. On the specific facts of this case, each of the four categories of allegations made in the suit, you'll remember what those are. We looked at them earlier. There are 4 different points, including, for example, one which was breach of the understanding. exactly what we have in our case. Numbers 3 and 4, connected party transactions, exactly what we have in this case.
Is the key the sentence on the specific facts, each of the 4 categories of allegations made in the suit raises substantial issues that are neither peripheral nor tangential? Because simply to adopt a test which is to decide what is not overly broad nor unduly narrow might be said, well, that doesn't really give you much guidance at all.
Yes.
So how is one to determine what is a matter on your submission? What is the test that you invite us to formulate?
Well, I mean, we would suggest that one has 2 options. Option 1 is simply to adopt the test that you see in paragraph 122. It has been expressly stated by Chief Justice Menon to be the test, and that in and of itself is workable. Now, it is fair to say that if you look at the Mozambique line of authority, they are perhaps a little more aggressive in their analysis, and they say any issue will have to go off. And it might be said that they don't even require it to be neither peripheral nor tangential. But we say none of this matters in the context of our case, because matters 1 and 2, I mean, it couldn't possibly be said that either of those 2 matters were peripheral or tangential.
Well, I understand that's your overall submission, but certainly for my part, I'd be grateful for what you submit is the appropriate test for a court to apply.
My Lord, I understand your point entirely, and I'm understanding that your Lordship's not happy with me adopting paragraph 122, and so what I'll try and do is give you my own 1 sentence, but I'll have to prepare that over the lunch adjournment.
Well, I'm not averse to 122 as being your submission. I mean, for you,
but my Lord, yes, I mean that's.
But certainly for me to say neither something which is not overly broad nor unduly narrow doesn't I don't think, to my mind, doesn't at the moment provide great assistance.
Yes, I mean, if one was being intellectually pure, there is much to commend the more aggressive approach of Mozambique and to say it can be any issue. Now, that has a logical attraction to it in that there is absolute certainty. And the answer to that, my learned friend says, well, if you take the more aggressive approach, is that you have endless fragmentation. But the answer to that is, no, well, no, you don't, because there are lots of mechanisms in play to avoid that particular result. And you see this in a number of the authorities. For example, Andrew Smith J. in Lombard addresses that very point. And he says, well, what do we do if you pick a tiny issue and you say, hold on, I want to stay in relation to that issue? So what happens then? Well, Andrew Smith says that there are 2 weapons available to the court which are regularly used. One is the Fiona Trust, which is to say everything falls within the scope of the clause in any event, so you avoid the fragmentation in the first place. But critically and importantly, you then have to work out what happens to the rest of the proceedings which are not the subject to a mandatory stay. And this is where the court comes up with clever approaches. So, for example, test it. Assume a very minor issue was plainly within, and this is a slightly unusual situation, but plainly within the scope of an arbitration clause. And everything else, which was important, wasn't. So on the Court of Appeal in Mozambique's approach, you would say, all right, well, that actually has to be stayed, if that is the position on the true construction of the arbitration clause. But you then ask yourself, well, is the court going to grant a discretionary stay of the remainder of the proceedings? And the court may well say, well, no, I'm not. Why should I grant a discretionary stay in favor of this very minor issue, which gets kicked off? And that is the key to all these cases. And you'll see it in Tomalugan, where the Court of Appeal is very clever in the way that they minimize the procedural irregularities. But this point occurs not only in relation to matters, but in relation to arbitrability. And it's very important that the court has a number of weapons available to it to ensure that you don't end up with what I might call silly fragmentation. And that is how it's dealt with. So it's very simple. So in terms of the rules of matters and arbitrability, you have a simple, firm rule. But in terms of how you then deal with the consequences of that, you have various mechanisms available to courts to try and streamline the proceedings. And you'll see in Tomalugan, for example, they're considering what to do when one of the shareholders isn't bound by the arbitration clause. And so the first question is that relevant to arbitrability? Answer, no. It's not. It's still arbitrable. But then the court says, okay, well, what do I do about this? And we'll look at this later. And they say, all right, well, I'm going to order that the petitioner makes an offer to the shareholder who isn't bound by the clause to join the arbitration. And if the shareholder says no, and then the arbitration takes place, and it then goes back to court, and that shareholder then says, well, I wasn't at the arbitration, I'm not bound, there's an abuse of process point. So that is a classic example of the court using clever case management procedures to minimize procedural complexity. But the key point, and this relates across the board, matters, arbitrability, whatever it is that the courts are absolutely clear that this type of point does not go to arbitrability. That is an entirely different type of question. And all these points are clever case management. And that some of them are very clever, as I'll seek to show you.
Can I ask you a couple of questions? The first is a very short one. Are you going to be taking us to the Tanning case?
I wasn't going to, my lord, but I was...
Well, can I just ask you then, the reference to it in Tomalugan is to a dissenting judgment.
Yes, my lord, yes.
I presume the majority had something to say about it.
Well, my lord, I would love to turn around and say, well, you can ignore it because it's a minority. I can't for this reason, that the majority didn't say much about it, but I have to take on the chin that in Australia, courts have run with that minority test in Tanning. So right. I can't, unfortunately, I'd love to discard it on the basis that it's minority, but I can't.
I see. And secondly, I may have missed something as we've been speeding round the racetrack, but why are we hung up on the definition of the word matter?
My lord, because my learned friend takes the point against me. So what my learned friend says is this. He says there are 2 points in this case. Arbitrability is one, but what he says is applying the Tanning test, there is actually only one matter, which is whether it is just and equitable to wind up the company. And he says you can't get any more granular than that.
Well, one...
And so that's...
Under the legislation, I mean, I presume that the relevant... that what we're trying to apply is Section 26 of the 2012 Act.
Well, my lord, it's relevant, yes.
Well,
I mean, what we're applying is Section 4 of the 1975 Act.
Ah, yes, that's right. And what's the expression used there?
That's where matter comes from.
Yeah. Right, that's the question I was asking.
I'm sorry, my lord, I should have made that clearer.
Right.
So this word matter appears in most of the relevant New York Convention statutes around the globe. And as I say, you have these 2 lines that one can try to reconcile. But my lord,
I'm sorry, 2169 is Section 26.
Yes. Sorry, my
and
lord,
that talks about a dispute. Yes.
my lord, 2191.
2191 is Section 4
It's
of
Section
the
4.
FA law.
So that's the key.
And again, you see the use of the word matter in the 4th line.
My lord, yes.
I see.
So that type of phraseology one sees in most statutes which seek to implement the New York Convention. So the New York Convention says to them, you must make sure that you respect arbitration agreements. And will you please enact in your local legislation a provision to that effect? And around the world, they come up with different slightly different wording, but all to the same effect as the one we're looking at now.
Yeah.
And so my learned friend takes this matter point against me and says it's so narrow that there is a matter is in this case is one and one only, which is whether it's just and equitable to wind up. And he says I can't go any more granular. And we say that's hopeless. Even on a tanning test, test it this way. Assume you had 4 breaches of a shareholders' agreement, and they were stated to be the basis for a just and equitable winding up petition. Just test it on that hypothesis. And you then had to ask yourself, well, what is the matter? If my learned friend was right, you could simply bypass an arbitration clause by saying, well, look at the relief. But my learned friend himself accepts that you don't look at the relief. It has to be something more granular than that. So we find it difficult to see how my learned friend gets home on this, whether you apply Mozambique or you apply tanning, to suggest that for example, the breach of the understanding is not a separate matter, we say is hopeless. It's obviously a separate matter, whichever test you apply. And I'll come back to that because there is a case which is bang on this point. What happened in Australia in a case called Hydrox, which I'll show you in a minute. I'm getting behind, so I'll take you to it relatively quickly. But what it shows is this. Australia applies the tanning test. Australia has a case on all fours to ours where you have a winding up petition. And the petitioner says, when faced with a stay application, but there's only one question. There's only one matter. It's whether it's just and equitable to wind up. And that's the only matter. And the judge says, no, it's not. You've got all the underlying matters. And this is applying the tanning test. And we say that judge was right. And I'll show you that.
Yeah.
I'm going to take you to it because it provides, we say, a very neat, sensible solution to the whole thing. So,
Are we going to go to tanning first? Or?
No, my lord, I wasn't going to go to tanning, simply because tanning doesn't help you other than give you the sentence which they say should be applied. And my learned friend may wish to go there, but I don't think it helps anything more than simply giving you what Tomalugan described as the malleable sentence. But let's go to, first of all, let's go to the in terrorem argument. And I'll just answer that very quickly. This is the multiple fragmentation point. And I referred you to the judgment of Mr. Andrew Smith J. in Lombard, and the point he says is, 1, principles of construction can avoid this. 2, even if they can't, you may or may not choose to stay the rest of the proceedings. So if one looks at 3894, and if one looks at paragraph 16, and this is Andrew Smith J. in Lombard, where he's dealing with this very point. This might lead to legal proceedings in which a referred matter is in issue, being stayed, whilst that matter or issue is referred to an arbitral tribunal, and then resuming when it's been resolved in accordance with the parties' agreement. This might be inconvenient and result in additional costs and delay, but that, and this is the key point, you see again and again, that is the price of respecting the parties' agreement and a risk that they are to have chosen to take. It might be a reason, and here's solution 1, for interpreting arbitration agreements expansively rather than restrictively, so as to avoid a conclusion that the parties intended that disputes should be determined in more than one forum, Suffione of trust, but where, as here, the parties have certainly agreed to refer to arbitration only certain disputes that might arise from their relationship. The risk of proceedings before both the courts and the arbitral tribunal is inherent in the agreement. See, that's the consequence of what you've agreed. It does not follow, he says, that wherever legal proceedings involve dispute about a referred matter, the defendant will necessarily be able to have them stayed, however peripheral the referred matter might be to the proceedings as a whole. It might be, for example, that while the referred matter is stayed for determination in arbitration, that's, in other words, the mandatory stay, the proceedings could otherwise proceed, but it is not suggested that these proceedings should be partly stayed. Lombard accept that if GATs are entitled to a stay under Section 9, to a stay of the claim for the first declaration, then the claim for the second declaration should also be stayed under the court's inherent jurisdiction, if not under Section 9. So you can see Andrew Smith saying, 1, if you get fragmentation, tough. That's what the consequence of your choice. 2, we can ameliorate the consequences of the fragmentation by broad construction of arbitration clauses and by case management in relation to whether discretionary stays are granted for the remaining parts of the petition which aren't subject to the mandatory stay. So those are 2 thoroughly sensible ways of dealing with the fallout. But again, and I'll come back to this again and again, one cannot get away from the primary hypothesis, which is that none of this is relevant, because it's the price you pay for agreeing the arbitration clause. That is party autonomy. So, to take you, though, to the solution in Hydrox, which is the Australian case, and that is at 7480. So here you have, as luck would have it, a case where there was a winding up petition and there was an argument about matters and what they constituted. So if you look at page 7484, and you'll see 7484 at paragraph 11. In their originating process, the plaintiffs claim a declaration that the affairs of Hydrox have been conducted in a manner oppressive to, unfairly prejudicial to, or unfairly discriminatory against WDR, an order pursuant to 2331A of the Corporations Act, or 461 of the Corporations Act, that Hydrox be wound up and consequential relief. And then in paragraph 14 underneath, you'll see, and this is important, in the present case, the only relief sought by the plaintiffs is the declaration in prayer 1 of their originating process and an order winding up Hydrox. No other substantive relief is sought. The prayer 1 declaration is claimed as a step along the path to the making of the winding up order against Hydrox. It is not a remedy or claim for relief which is sought independently of the plaintiff's claim that Hydrox should be wound up compulsorily by the court. So you have the very point coming to the fore. So in effect, as you'll see in a minute, you have one party saying, well, there is only one matter in this case, and that is, should the company be wound up? And the other party says, well, hold on, what about all the underlying points? They're matters too. Held, they are matters too. So if one looks at 7492, you'll see the plaintiff's case at paragraph 54. In prayer 1, the plaintiffs set out the grounds upon which they rely for the declaration, which they seek for the winding up order, which they seek. These grounds may be summarized. So here you have, in effect, particularization of leg 1 of the petition, the underlying complaints. Leg 2, of course, was the winding up. So we're looking at the underlying complaints. You've got misconduct by directors in various different shapes and forms. You can see that from little a, little b, and little c. So similar to our case. So as in our case, you have ultimate relief winding up, lots of underlying disputes, including directors misbehaving and all the rest of it. So what's the matter? Answer is on page 7504. And at 7504, you'll see at the bottom 102, identifying the matters the subject of the proceedings. In order to ascertain whether the court is obliged to grant a stay pursuant to section 72B of the IAA, it's incumbent on the court first to decide whether the court proceeding involves the determination of a matter that, pursuant to the arbitration agreement, is capable of settled by arbitration. And then over the page at 7505, you'll see that in addressing this point, they quote and apply tanning. And that's because we're in Australia. So the tanning test, you can see at the bottom of 7505, they cite from Dean and Gowdron JJ. They are the minority in tanning that I was asked questions about previously. And over the page at 7506, you'll see at the top of the page the citation, if you pause there, the citation from tanning, and about about 10 lines down, you'll see, or eight lines down, it requires that there be some subject matter, some right or liability in controversy, which, if not coextensive with the subject matter in controversy in the court proceedings, is at least susceptible of settlement as a discrete controversy. So that's your tanning test. We say malleable, and Men on CJ says malleable. And then underneath, 110, a matter for the purpose of Section 7 may or may not comprise the whole subject matter of any given proceeding. A matter is something more than a mere issue or question that falls for decision. As submitted by the plaintiffs, the court must first identify the matter or matters to be determined in the proceeding before asking whether those matters fall within the scope of the clause. The plaintiffs argued that in the present case, there is in substance only one matter involved in the proceeding for the purpose of Section 7, namely whether Hydrox should be wound up on either of the statutory bases relied on by the plaintiffs. The plaintiffs contend, that's the petitioner, that difficulties arise if one attempts to pass the proceedings into separate subsidiary matters. They went on to submit that the court is being asked to exercise a power, a precondition to which is the formation of an opinion of the court as to the appropriateness of the relief. You'll see so many of these arguments reflected in what my learned friend is arguing now, and they're all rejected. Under Section 233 of the Corps Act, the court is directed to form such an opinion by the use of the word considers. Again, this point's now taken against me. In the chapeau to Section 233 and Section 461, over the page at 7507, the plaintiff submitted the court cannot delegate the formation of the relevant opinions to a third party, such as an arbitrator, nor can the court delegate to a third party the ultimate determination of subsidiary facts or issues for the purpose of the court forming that opinion. So the petitioner is saying, well, you can't delegate either the main question of whether it's just and equitable or any of the underlying issues underneath. They're not matters. There's only one matter, and it's do you wind up? So exactly what my learned friend is saying. Plaintiffs went on to submit that such an approach would be inconsistent with the language of the Act, which confers the power being exercised, and inconsistent with the nature of the Act, which is a power in rem. The submissions made on behalf of the plaintiffs, which I've just referred, were then linked to the plaintiffs' arguments to the effect that the subject matter of the present proceeding is simply not arbitrable. And then underneath at 116, Woolworths submit that the subject matter of this proceeding was not one matter, but comprised several matters. In its written submission, Woolworth characterised those matters in the following terms. And what they do then is identify lots of different issues which arise, which form the basis of the winding up petition, just as we do in our case. And if one then goes to 121 to 122, in light of the arguments to which I've been referred, Woolworths ultimately submitted the present proceedings involved a number of matters, being the matters identified at 116 above. In my view, there are several matters involved in the present proceeding. The present proceeding is not to be regarded as one single matter. Although the authorities make clear that not every question or issue constitutes a matter, they also make clear that in any given proceeding there may be more than one matter involved. When proper regard is paid to the grounds relied on by the plaintiffs, support of Prayer 1 in their originating process, I think there are several matters involved in the present proceedings. The identification or characterization of those matters propounded by Woolworth seems to me to be arrived at by an appropriate analysis undertaken in accordance with the relevant principles. The conclusions necessarily involve the rejection of the plaintiff's primary submission. The effect there is only one matter. So they then go on to deal with arbitrability, and I'll have to come back to that later.
Yeah.
But
the passage quoted from the judgment of Justices Dean and Gowdron is there's rather more to it than one might have thought from reading Tamalugan. If one goes to 7506 and looks at the first paragraph, starting about 7 or 8 lines down, they say the expression matter capable of settlement by arbitration indicates something more than a mere issue which might fall for decision in the court proceedings or might fall for decision in arbitral proceedings if they were instituted. And that's the sentence that is picked up on in Tamalugan. But they go on to say it requires that there be some subject matter, some right or liability in controversy, which, if not coextensive with the subject matter in controversy in the court proceedings, is at least susceptible of settlement as a discrete controversy. So that's
yes, but, well, my lord, that's exactly what I call the Tanning test. So it's that sentence that your lordship has just read out that the Court of Appeal described as malleable, obtuse, and difficult to apply. So that is the Tanning test. That is exactly what was considered by the Court of Appeal in Tamalugan. And you will, of course, have seen Lady Justice Carr refer to and rely on Tamalugan as providing the correct approach to a matter. And one of the points made by the Court of Appeal in Tamalugan is, well, we just don't understand what that means. Now, if one applies tanning in the context of this type of scenario, you can see exactly how it works in Hydrox. where the judge, applying the Tanning test, says, well, no, you can't simply say there's one matter in this context. There's lots of matters. And you've got to look at the underlying disputes between the parties. And just to hark back to the example of what happens if somebody does seek just and equitable winding up, and all that's in issue are 5 or 6 breaches of a shareholders' agreement. And unsurprisingly, one might be met with some surprise if one said, well, if you allege 5 breaches of a shareholders' agreement in the context of a winding up petition, then the arbitration clause is gone, because that's not a required matter. And you could sidestep it in one easy stroke of the pen by applying for a winding up petition.
Do I understand you to say that should that be the appropriate test, each of those various elements, if I can call them that, would be capable of being resolved by settlement?
As a discrete controversy.
As a discrete controversy.
Precisely. Your Lordship has the point that where I started out on this journey was that it doesn't matter. And we do submit with some force, I hope, that if you look at those underlying matters, they all satisfy the Tanning test in any event. I mean, let's just unpick some of them. There is an allegation that the majority directors breached their duties to the company. Why is that not, quote, some subject matter, right or liability susceptible of settlement as a discrete controversy? Let's look at the understanding. There is an allegation of a breach of the understanding. Why is that not some subject matter, right or liability susceptible of settlement as a discrete controversy? But, and my learned friend might say, well, it's not a breach of contract, but the answer to that is obvious when one looks at all the cases on Westbourne galleries, etc., which do expressly say that when you're looking at an understanding, you are looking at equitable rights. And indeed, my learned friend to some way gives away the game by the way in which he describes the understanding in his written case. He says that the understanding, this is, and I quote, and just for your pen, for your notes, you don't need to turn it up, 2132. This is an allegation of a breach by the appellant's involvement in a Westbourne galleries type understanding. And at 2137, the petitioner's case is that there has been, quote, a breach of the arrangements which were intended to bring transparency to related party transactions. And at 2137, they say, and I quote, it's true that the existence of an understanding between the respondent and the appellant is covered by the arbitration agreement. And none of this is remotely surprising when one analyzes Westbourne galleries type cases, and they give rise to, and I quote, equitable constraints on a party's exercise of legal rights. And you'll all no doubt remember the famous words of Lord Hoffman in O'Neill and Phillips, where he says, and I quote, but there may be later promises after the articles by words or conduct which would make it unfair to allow a member to ignore, nor is it necessary that such promises should be independently enforceable as a matter of contract. A promise may be binding as a matter of justice and equity, although for one reason or another it would not be enforceable in law. So we do say that, and I'm not trying to dodge the issue, but we do say that the facts in this case are so clear that if you did choose not to decide the matter point, you could. But on the matter point, I would endorse the approach of Chief Justice Menon in the Tomalugan case and the approach of Mozambique in the Court of Appeal. And you might tease me and say, well, are they really identical, Mr. Kimmins? And I'll have to mull that one over the lunch break, if I may. And if it means I have to come up with a separate sentence, then I will, in answer to Lord Kitchen's question. But we say that doesn't matter at all. So on the facts of this case, we say none of that matters.
Yes, the point in O'Neill and Phillips was to get some discipline into what became Section 994 petitions by saying it's not just a matter of a broad concept of fairness. You have to tie it into a contractual right or an equitable right.
Constraint, exactly.
Yeah, equitable constraint.
That's
yes.
the language they use.
Yes, and you say these are matters that could be capable of resolution and settlement.
Precisely. If you apply the Tanning test, you've got no problem. Yeah. And you've got the same with the breaches of directors' duties. You've got the same as the procuring the breaches of the director's duties. Just to take up a couple of points there. In Hydrox, of course, the wrongful voting by the nominated directors and wrongful conduct in a corporate governance sense, that's the phrase they use, those are all matters which satisfy the Tanning test. And you've got an allegation of breach of fiduciary duty by Sir David in the Fulham Football Club. Again, that's, it's never been suggested that that isn't a matter which would qualify. You've got Sir David in Fulham Football Club causing the FAPL to act in breach of its articles, just as the allegation against us is that TC caused directors to act in breach of their articles or in breach of their obligations. Again, these are all capable of settlement or discrete controversies. So the point doesn't arise, albeit it is very interesting. So that's matter. And
Can I just take you back to the key words of what you identify as the Tanning test? It requires that there be some subject matter, some right or liability in controversy. That presumably means a right or liability as between the parties to the arbitration.
well, one doesn't, no, I mean, one doesn't know. This is one
I'm
of...
just thinking of the claim about directors' breach of fiduciary duty. I mean, in a sense, if a minority shareholder complains that directors have been acting in breach of their fiduciary duty, A, he's got no direct claim against the directors because they all their duties to the company. And B, it's not something which could lead to any settlement or a right or liability as between him and the majority shareholder. Leave aside the allegation that the majority shareholder connived to it.
Yes, well, I mean, I think we would say that's reading a little bit too much into the particular phrase in Tanning. But as you say, on top of that, you've got the connivance point in any event. And you've got the understanding, which is the very basis of the entire winding up petition. So one isn't short of points which would qualify even on your lordship's gloss on the Tanning test.
Well, I'm not in the gloss, I'm just trying to understand.
My lord, yes, yes. But I mean, in some ways, the very fact that we debate these points gives further credibility to the Mozambique approach, which is to say, well, it's much simpler than that. And you don't need to look at whether it's a big issue, a minor issue, it gives rise to a cause of action. If it falls within the arbitration clause, then the New York Convention, as enacted in your country, tells you it has to be stayed. End of story. And that you then deal with the consequences by either broad construction of arbitration clauses or by case management directions, which I'll come on to deal with later. But there's a lot of attraction in that very simple approach that you see in Mozambique. I want to move on.
In this particular case, am I right in saying that the directors of Ting Chuan also were the controllers of Ting Chuan?
My lord, I think
I saw that in the
I think that's
papers,
right. Yes,
they
my lord.
controlled both Ting Chuan and also the related party companies about whom complaint was taken.
Yes, by majority shareholding.
By majority shareholding.
My lord, I think that's right.
Yeah.
I think that's right. So, my lord, I've got a little bit behind. I've got 5 minutes, I think, until we were going to break at 1:30. But if I may, I'd like to use them. Arbitrability, I will deal with as quickly as I can. I'm going to look at 5 points. Point number 1 is to look at the broad test for non-arbitrability, and there's a good degree of common ground there. Point number 2, the relevance of remedial inadequacy and procedural complexity to the issue of arbitrability. Point number 3, I'm going to look at the authorities which consider whether disputes underlying a petition to wind up on just and equitable grounds are arbitrable, because there are authorities on the point. Fourthly, I'm going to consider what I call the options available to the court in this case on arbitrability. And I'll come back to this, but they are essentially either matters 1 and 2 are arbitrable, and we say, if that's the answer, we win, because it's common ground that 3 and 4 would have to be stayed as a matter of discretion. So that's option 1. Option 2 is matters 1 to 4 are all arbitrable, where we still win. And option 3 is none of it's arbitrable. And we say, it's taking a sledgehammer to crack a nut, and in any event, almost all of my learned friends' arguments are based on procedural inadequacy or procedural complexities. And then I've identified 4 points I was going to deal with. The 5th one is to consider the arguments which my learned friend makes in his written case. He makes about 7 or 8 arguments on arbitrability, and I'll just unpick those as quickly as I can for you as the last part of my submissions on arbitrability. But let's start with the broad test for non-arbitrability. And we say that there must be compelling reasons for something to be non-arbitrable, and there is also a presumption in favor of arbitrability. I don't want to go to all the authorities on this. I think the easiest thing is just to give you a cross-reference to our case, the appellant's case at paragraph 46, which is at 2058, which deals with those points, and there are a lot of English authorities which make good both those propositions. One, the requirement of a compelling reason, and 2, a presumption. And I'd also add, just in terms of...
I missed your page number for your case.
2058. In addition, just a forensic point before lunch. It is very, very rare to find in modern times a decision that all or parts of a commercial dispute are non-arbitrable. And the modern approach is encapsulated in many of the textbooks which are in the bundles, including those, for example, there's one by Karim Youssef called The Death of Inarbitrability. And the clue is in the name. Now, in your bundle, you have 37 cases where somebody ran a specific non-arbitrability objection in all sorts of different jurisdictions. In 32 of them, the non-arbitrability objection was rejected. So there are 5 where it worked. 3 of them have since been disapproved or overruled: Exeter City, Bestflor, and Larson. One of them was where it fell within the employment legislation, and that's the case of Irwell, which is one of the cases that Lord Reed, one of the special statutes that Lord Reed mentioned. And the other one is a New Zealand case in 1977 called Re-Seed Coating, which is an ex-temp judgment, which I'll come back to later. And that's it. And all the rest, the courts have said, no, autonomy will trump. And I would encourage your lordships at some point to look at all the cases such as Bridge House, London Steamship, NDK, Norrie Holdings, River Rock. These are all recent, very recent cases, whether it's Mr. Justice Foxton, Lord Justice... Sorry. You may well be right. Yes, I'm going to come back to Bridge House later, but they're quite striking, some of these recent cases. I mean, for example, you'll have an allegation that a petition to set aside a transaction under a Russian bankruptcy code was non-arbitrable. Held no, it's arbitrable. And that just gives you an example of the power of party autonomy. And I just would invite your lordships just to bear that in mind. But before I get stuck back into what I call the 2-part test, the statutory restrictions on arbitrability and the public policy restrictions, those 2 different elements that we looked at earlier, that's what I want to address when we come back after lunch.
A convenient moment for us to adjourn, and we'll resume at 2:30.